Major breaking news out of the United States District Court for the Eastern District of Virginia, based in Alexandria, Virginia. A major lawsuit brought by plaintiffs against Daniel Defense and other gun-related companies, claiming that they were somehow involved or helped cause, through their business practices, a terrible shooting that occurred in Washington, D.C. But the judge saw through this, pointed out that the complaint failed to allege specific causation between the actions of Daniel Defense on the one hand and the shooter, criminal shooter on the other hand, and therefore dismissed this lawsuit against the gun industry and Daniel Defense. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks by Hamas on Israel Teach Americans About the Right to Bear Arms. We must always learn from the mistakes of others so we don't make the same mistakes here in America. We never want to lose our right to keep arms. A lot of critical historical and international information in Israel Disarmed. Check it out on Amazon. All right, folks, major victory here for the gun industry and Daniel Defense, major gun company, obviously. Out there in Virginia, the United States District Court for the Eastern District of Virginia. Unfortunately, there was a shooting, criminal shooting that occurred in April 2022, where apparently some gunman, a shooter, opened fire from his apartment window, or an apartment window, overlooking a school. Several people were shot, and ultimately, this lawsuit was commenced by the people that were shot by this gunman, by this criminal. They alleged the plaintiffs, in order to presumably get the gun industry brought in to pay money or harass them, whatever was the motive is, who knows, whatever it was, they brought a lawsuit. And the plaintiffs alleged that the defendants in this case were manufacturers of quote-unquote assault rifles, rifle accessories, and ammunition. They claimed that the defendants, such as Daniel Defense, were negligent and violated all sorts of state laws. And specifically, they said that this is what the plaintiffs alleged, that the defendants have deceptively and unfairly marketed their assault rifles and other products in a way that was encouraging or appealed to really people that would misbehave. It's the essence of the complaint here. I'm happy to report, though, that the federal district judge took a look at this complaint and said that, simply put, to make a long story short, that there was not adequate allegations connecting the conduct of the defendants, such as Daniel Defense on the one hand, and the actions of the shooter. The court pointed out that you have three sort of sets of parties, if you will, involved in this case. You have the gun companies, such as Daniel Defense, that are making a lawful product, no dispute there. Then you have the people that were shot. That's the second category of people. And then the third category of parties or people, of course, is the shooter himself. And the judge points out that the only way that you can even consider, for standing purposes under federal law, to go to federal court and hold a defendant liable for the actions of a third party, in this case, the third party was the shooter, is you got to show somehow or allege somehow that the actions of the defendant, such as Daniel Defense, did something that encouraged, coerced, caused, if you will, the shooter to engage in his criminality. And the court said there's simply nothing in these allegations that would suggest that Daniel Defense or the other defendants somehow coerced or encouraged or did anything to get this nutty shooter to engage in a violent crime of attempted murder. Simply not enough there. And as a consequence, the judge said that as a matter of standing under Article 3 of the U.S. Constitution, as you know, federal courts do not have jurisdictions over a case unless there is a case or controversy between the parties. They are not in the business of just setting forth hypothetical rulings. In hypothetical cases, there has to be an actual dispute. And here the judge said that there was no case or controversy because the requirement of standing, meaning that the plaintiff had been individually injured by the conduct of the defendants, and, to make that causal connection there, the allegations were just not specific enough to allow the court to find that standing existed under Article 3 of the U.S. Constitution, and that alone allowed the court to dismiss the case. But then the court went on and pointed out that the lack of proper causation allegations also would allow him and caused him also to dismiss this lawsuit against Daniel Defense and the other defendants under the Protection of Lawful Commerce and Arms Act. As you may know, the Protection of Lawful Commerce and Arms Act, or PILCA, sometimes it's referred to, protects gun companies from engaging in lawful conduct for being sued for third parties over whom they have no control for criminal activities. Because what was going on in the 1990s during the Clinton era was that cities and others were suing gun companies for the criminal conduct of shooters over whom they had no control. Congress in 2005 enacted, again, the PILCA, Protection of Lawful Commerce and Arms Act, to protect the American gun companies for many reasons, one of which, of course, is if you want to have national defense where the military and the police can acquire their firearms to protect the country, well, you better have an arms industry. Otherwise, you have to go begging Mother May I, like the Ukraine does, and to some degree Israel does, to come to the United States begging Mother May I, can you please sell us arms, because we don't have a domestic arms industry that's adequate to protect ourselves in the case of Ukraine against the Russian invasion, in the case of Israel against the terrorist attacks and the threats from countries like Iran. So the point being, though, that in 2005, with the support of the Pentagon and, of course, the Second Amendment community and the gun industry, all stepped up and said to Congress, we need to enact a law that protects the gun industry from these frivolous lawsuits where people are suing over the conduct of these criminal nut jobs using a product that we made. This is not fair any more than it would not be fair to sue a baseball bat company because someone used a baseball bat to commit an assault, or it would also not be fair, as I've written about before in some law review articles, it would not be fair, for example, to hold a Betamax company, a VCR company, a DVD company, any kind of a communication entity like that, hold them liable and responsible if someone decided to use, do illegal copyright or illegal conduct using those VCRs, those Betamaxes, those CD players, whatever it was. You can't hold the manufacturer of those products liable because someone misuses the product, because anything can inevitably be misused or could be misused for criminal conduct. So that's why Congress passed the PILCA. And this is another point that the judge made as he dismissed this lawsuit, to say that obviously Daniel Defense and the other defense were making firearms and firearm component parts and ammunition, and therefore they're protected under the statute, and none of the exceptions applied, because he said to the extent an exception could apply, there has to be a specific allegation that says the defendant somehow violated the law, and that specifically caused the shooter to do something terrible. And he basically said, the judge said in this case, that was just not adequately alleged. And of course, the case was ultimately dismissed. So anyway, again, a major win for the gun industry, a positive development. Of course, the big development that we're going to have to watch carefully is, does the Supreme Court grant cert in a PILCA case before the U.S. Supreme Court now involving the government of Mexico? We probably need to cover that in a future video. We will not know whether or not the Supreme Court is going to grant cert in that case, where, as you may recall, the government of Mexico sued a whole bunch of gun companies in the absolutely terrible, crappy anti-gun jurisdiction of the United States Court of Appeals for the First Circuit out of Boston, which is literally the worst court in America for the Second Amendment and anything relating to guns. There's not a single judge that I'm aware of that's capable or good on any issue touching on guns or the Second Amendment in the entire First Circuit at the Court of Appeals level. At least they're absolutely that pathetic when it comes to our right to keep and bear arms. So there'll be no redress or nothing positive that comes out of the First Circuit, which involves Boston, New Hampshire, I think Puerto Rico as well, and Rhode Island. Nothing good will come out of those jurisdictions with the current composition of the U.S. Court of Appeals, and they ruled in favor of the government of Mexico in that case. And the question as to whether or not the Supreme Court will grant cert in this case will be decided likely in September during what's known as the long conference before the U.S. Supreme Court. But again, we won't know about that until September, and we'll cover that when the time comes. But in the meantime, major win for Daniel Defense and the gun companies involved in this case of Lowy versus Daniel Defense. Congratulations to the lawyers and to the defendants, and we'll keep you apprised if there's some developments in this case and others. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you subscribe to this channel. Don't forget to follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.